So it's a great pleasure for me to introduce today a discussion that we're going to have for the next 3 hours on the quite exciting topic of intellectual property and antitrust law interface in the global economy. This is a roundtable that is sponsored by Skolkovo Foundation. And we have the pleasure today and the honor to have some exciting speakers and leaders of this particular area. And I will probably spend some time first introducing them, although I know that all of them actually do not really need an extensive introduction and that everyone is aware of their achievements. My name is Ioannis Llanos, and I'm a professor at University College London in the area of competition law, and I also work in the area of intellectual property law. So yeah, great pleasure for me and honor to welcome today Igor Artemiev. He's the head of the Federal Anti-Monopoly Service at the Russian Federation. Mr. Artemiev has a background both in science and law, and he has done studies at the University of St. Petersburg. He has been the head of the chairman of the Federal Anti-Monopoly Service since 2004. Thank you very much, Professor Artemiev, and as well as a professor at the university, the Higher School of Economics. Great pleasure also to introduce Judge Novoselova, who is the chairwoman of the Specialized Intellectual Property Rights Court that has been established in 2003 in Russia. She was formerly a judge at the Supreme Arbitration Court, and she's also a professor at the University of Moscow and a specialist in the area of intellectual property law. A great pleasure also to introduce an old friend, I would say, Professor Frederic Geny, who is the chairman of the competition committee at the OECD. And he's extremely well known in the global competition law circles. He is an economist by background, but he has also been appointed a judge at the French Supreme Court, Cour de Cassation. He has also served as the Vice President of the French Competition Council and also a member of the Office of Fair Trading Board, so an important experience. A great also pleasure to introduce Rochelle Dreyfus, Professor Rochelle Dreyfus from the University of New York University Law School. Professor Dreyfus actually was my professor in patent law, kind of many years ago. I will not disclose how many. She's a professor of intellectual property law and patent law, and she's also the co-head of the Engelberger Center at NYU on innovation policy. She has a lot of experience in the area of intellectual property, but also the interaction between intellectual property law and competition law through the work she has done with Professor Harry First from NYU in this particular area. A great pleasure as well to introduce Professor Andrei Sastiko. He's a professor at the Lomonosov Moscow State University. He's an economist, and he has been the co-author of the first, as I understand it, impact assessment report on the intellectual property system in Russia, which you will find located on your next to you, I guess. It's actually a quite interesting report. I have some discussions with some colleagues at the UK Intellectual Property Office before coming here, and they were very excited to see how this impact assessment report looked like. It's really very difficult to do an impact assessment of the effect of intellectual property rights on the economy, so we look forward to hear the conclusions of Professor Sastiko. And last but not least, I will say it's Alexei Ivanov, who is representing Skolkovo Foundation. He is the Director of Legal Policy and Social Development at Skolkovo. He's a graduate of Harvard Law School, and he has done also a lot of research in the area of intellectual property law, in particular focusing on parallel imports. And you'll see that there is a section of this particular report here that he has co-authored, which also includes quite interesting thoughts and thought-provoking thoughts on parallel imports. And I will say that we will also have the pleasure to hear and to see, to watch, but unfortunately he could not make it today, Professor Bill Kovacic from the George Washington University Law School. He was a former chairman of the Federal Trade Commission, an extremely well-known figure in the area of global antitrust law, with a lot of experience also with regards to the interaction between competition law and intellectual property. He unfortunately could not make it today, but he has prepared a short film, which we will show with some answers to the questions and some contributions to our discussion. So I will actually start the discussion by asking Judge Noloselova to introduce a little bit the state of play of intellectual property law in Russia, how that actually evolved, and in particular to discuss also about the establishment of the specialized court and what exactly will be, according to her thoughts, the impact of this specialized court on the way intellectual property law is enforced and practiced in Russia. Judge Noloselova.
Thank you very much, dear colleagues. For me, it's a great honor to speak in the framework of this forum, and in particular in this session, because I'm currently taking a new position for myself, which is the judge of the Court on Intellectual Property, and I would like to share some information to you. I hope it will prove sufficient. I'll tell you about the idea, how we came up to establish the new court, and about some specific aspects that characterize the courts in our country. The idea itself to establish a specialized court that would deal with the cases related to protection of IP rights, disputes related to patents, disputes related to decisions in patents, appeared quite a long time ago, already in the Soviet period of time, when a number of laws were introduced. And at that time, the necessity to establish the specialized court was voiced, and a lot of interesting discussions followed suit, but the court was never to be established. And well, due to these changes in our state system, the ideas was never realized, and for a long time, the disputes in this particular area were not carried out in accordance with this new initiative. We know that the disputes related to the withdrawal of patents or non-issuance of patents have to be dealt in accordance with the administrative code, and the bodies that are currently well, all the issues related to guaranteeing intellectual property rights and providing the property rights were dealt with by the normal courts. Actually, it only impedes such disputes. All the court hearings are very costly, because every time when you deal with patent applications, you require costly expert reviews, which takes a lot of time and a lot of money, and that makes the whole procedure, this court disputing, makes it very inefficient. Moreover, the lack of specialization, and that's the opinion of all the participants in the market, leads to insufficient practice in the sphere. So that is one of the issues. The other one, and that is why we started discussing whether or not to establish the specialized court for the last 5 years, and it's always been in the public domain. However, the idea was completed. I mean, the final project was voiced in 2009. Mr. Ivanov has said that this specialized court has to be established within the arbitrage system. Maybe you're all aware that our system basically consists of 2 systems or subsystems of court systems, meaning court of common or general jurisdictions that deal with disputes with private individuals, and arbitration courts that deal with business cases. So the Court of Arbitration of Russia has served as an initiator of that kind of courts. Why this idea came up and why it was later fixed in the law. We do understand that when entrepreneurs dispute intellectual property rights, the cost of those intellectual property is huge. And today, since the intangible assets, the IP is getting more and more costly, is becoming more and more expensive. Everybody today understands that the standard types of assets will going to go down, but intellectual assets, as I call them, will take over, and its share will grow significantly in the near future, and we understand this trend, we see it already. So in order to protect the interests of the business, in order to protect the investments into this particular sphere, it seems only right and only feasible to separate those cases that used to be dealt by the arbitration courts into this specialized court. Well, that explains why the court had decided to. This new court appeared within the system of arbitration. The law on establishing the new court on IP rights was adopted in 2011. By the end of this year, today, we can already say that the court exists. However, it has not yet started working, and I will explain later why. We hope to already receive and hear the first cases in June. Now is May, so only little time remains until the court will be fully open and will work in full swing, when it will make justice. And now a couple of words about the specificities that characterize our new IP rights court. It is quite unique, and it takes a unique position. I will reiterate that the court stays within the system of arbitration, so it dwells in this domain. However, as to its level, it's the court of cassation. However, it reviews the disputes of the first instance. That's the first category of disputes, and I will talk about that later. And it can also serve as a court of cassation for all other disputes that are dealt by the arbitration courts, the other arbitration courts, and are somehow related to the IP rights. So, this court, being the only one of its kind in the Russian Federation, it can accumulate all the disputes that are reviewed by the first and second instance courts. And that system, I think, will help us to realize the task of which we talked constantly, that we have a single, or at least unanimous, we'll have common practice, because today we cannot create this common practice in the existing arbitration courts of arbitration. The highest arbitration court can do that, yes, but since it's not the main line of business for the court, so to say, there are a number of issues that are, for example, too low for the court to decide upon, and it's not quite feasible for them to decide because it's not their main activity, so to say. And for that specialized court, its main task would be to track all the existing practice in the lower lying courts, and then it might make a decision whether to review such cases or not. So probably the High Court of Arbitration will have nothing to do at all in the end, because for them it's just to track whether the practice is uncommon, and if we're going to relieve it from some of its authorities, then we will make their life easier. I'm kidding, of course, because you will understand perfectly well that some of the issues will be dealt with by the highest court of arbitration. by the highest court in this line, and sometimes we will even ask them to come and interfere to either approve or not approve our practice, but at least their services will be of a great need to us still. So, this set or range of issues is the most important for our court, I believe. And it's very specific because not everywhere else in the world we have a court that would accumulate all the disputes of that kind. At least at some instance, but these disputes or these cases will come all over from Russia in one place. And this court also serves as the first instance court, but the category of disputes that are reviewed in the first instance are identified by the law, first and foremost, disputing normative acts of the federal executive authorities in the area of intellectual property rights. These norms and regulations are currently reviewed by the highest court of arbitration in accordance with existing legislation. As soon as our court will come into full force, so we will review them ourselves. Now, apart from that category of disputes and cases, and this is a chunk we've taken out from the High Court of Arbitration, the other category of disputes that we will be dealing with is related to the revision of non-normative acts that are related to withdrawing patent rights from certain entities. For example, we can deal with Ross patent and their acts and decrees that they issue and other agencies and bodies like that. Now, apart from that, our court will also deal with the disputes that are related to preliminary cancellation of trademarks and so on and so forth. And other categories of disputes, like it was ruled by the Presidium of the highest court of arbitration. Also claiming losses that were incurred by implementation of normative acts. This particular disputes are not included into the original list of disputes we had to deal with, but it will be added very soon. So we would also dispute those acts that are related to carrying out other court acts, and this question is currently in discussion, how best to deal with that. However, I don't believe we should go that far into details, and now I would like to proceed with one other question, which I think might cause some discussion, should we arrive to a discussion. The thing is, the cases that stay within the jurisdiction of the courts of IP rights, as of the first instance, they cannot be appealed for. You know, in the normal way, you would have the first cassation, the appellation, and the regulator. Actually, in our case, we don't have the Court of Appellation, but we have the Court of Cassation, and the Court of Cassation stays within our own court, but this court works within a presidium, and it reviews those decisions that were made before that. So, and there are two basic issues. Why don't we have the Court of Appellation when we can't appeal to another instance? Well, for that I can give you the following answer. However, this answer can evoke opposition from your side, but this answer is quite self-evident, and it is like that. Since the court reviews and revisages those decisions that were made in an administrative way, maybe there is no need to deal with factual issues, because the body that originally reviewed the issue at hand had already dealt with all the factual things, and our first instance does not is not in fact the first instance. Actually, it's already the appellation instance. So that's how I see the whole process, and probably it will not be feasible to ensure another instance.
So we should rather think about the application of the law and not the review of facts. Secondly, two instances within one court may also raise some criticism, because this combination is always controversial. Why judges belonging to one and the same court review the decision of their own colleagues? Well, I'm in a very difficult position because I have to find the right organizational procedures to mitigate this problem. And from the organization point of view, we can do the following: is really to put Chinese walls between the judges who work as judges of the first instance and judges who review or consider the appeals. So there must be two absolutely different groups of people. Still, I believe that we should once again reconsider the structure of this work, and we do understand that the available law requires improvements, changes, some upgradings, and there is a special group to collect various proposals and comments to the draft law, but this is an innovative law for us, and we are ready to do our best to change the procedural law. So if you have any comments, any ideas on the topic, I'm ready to listen to you attentively and to make notes. And in any case, we are open for any constructive criticism and for any positive contribution coming from lawyers and from other stakeholders. Another important aspect that should be highlighted. One of the main remarks that we get is the need to use very expensive expert examinations. To eliminate this step, we suggest the following. The court creates a group of experts who are public servants, employees of the court, but they are not judges. They have either technical or any other scientific background, and who are supposed to provide assistance to the judge if the judge is unable to go into details or to understand all the particulars of the case. So these people will not undertake any physical examinations. They will just act as counselors and advisors, explaining the difficult definitions. We yet don't know the exact functions and duties of such people. It's not yet defined. But in addition to them, the court may involve any qualified expert, so an engineer or a technician or a scientist can be invited by the court to provide its expert judgment on a particular case. From the functional point of view, they are the same, but from the structural organization, they are different. So one will be employees of the court, they will be, and the others will be hired by the court for some limited period of time. As you can see, we already come to the discussion of details. And as I spoke with a specialist today who told me that usually an invention is very easy to make, but when you put it into the production, then the game starts, because the process engineers say, we don't have this type of metal, we don't have this type of machinery, we don't have this type of life. So the invention must be adopted to the practical life. So now we are doing this adaptation. We try to squeeze the ideas that we have invented into the real life. So one of the main topics is to create this pool of experts within a court, because they're supposed to be civil servants. There are some certain limitations to their candidates and requirements to their background and education. And I can hardly imagine engineers or scientists or biologists who will be willing to work in a court, taking into account a not very attractive salary or all other limitations related to civil service. And another topic is who must be in this group. We have only 15 positions, and 15 people may not cover the whole range of intellectual property issues. We understand that chemists may be well experienced in the organic chemistry, but may not be knowing anything about non-organic chemistry, because there are two different branches of one and the same science. So, I want to attract your attention that this hiring or involvement of experts needs a lot of discussions, and most probably we shall see all our drawbacks and we shall see all our gaps if and when it is practically implemented, and only afterwards we shall be able to adjust all of these issues. Another topic is, let's say, related to or interested parties, because there are a majority of comments that people might be interested.
With a question that I think also some of the speakers will also be interested from abroad. In particular, the pool of experts that you have and the disciplines that you just mentioned. Imagine that, for example, you have a competition counterclaim that comes to your court. Will, in this particular case, you'll be dealing with this? I'm not familiar with the procedure in Austria. Will you be referring a question to the Federal Anti-Monopoly Service, or will you have the opportunity and the possibility to recruit competition specialists or maybe economists as experts in order to help you resolve this issue? And we'll think of an antitrust counterclaim in refusal to licensing type of case that might come to your or patent infringement type of case that might come to your court.
Well, in addition to the involvement of experts, we have to define, let's say, the competence of this expert. If we need any special knowledge, we may invite an economist or a competition expert. I don't think that we shall be able to invite people from FAS, because usually the court is considering FAS decisions. And if it's FIS who first judged whether there was a violation on competition or not, so that there will be a conflict of interest in this case. But let's say if it's not. If it's out of FAS competence and we need their qualification, in this case, yes, I believe that we can invite people from FAS. Well, in addition to the experts that I mentioned, we can also send inquiries. So a court may send a letter to a competent person and get the answers. Once again, this is not technical examinations, these are not lab studies, these are just the clarification of specific issues. So we can send this inquiry to anywhere.
Discuss with President Temif, yes. Yes.
Я просто хочу сказать, что, конечно...
Yes, I would just wanted to highlight that this new court will be a superior instance to FAS, and it's not a legislative branch, it's the executive branch or judicial branch. And most probably we shall act as third parties in this court. For example, if a company decides to address right to the court bypassing FAS. So in this case, the court may invite us as experts and specialists in competition. But we do believe that FAS will act first, that we shall make the first reviews, because court proceedings are rather expensive. So we hope that the companies will choose to come to us first, and we shall go together to the court if and when necessary.
What we learned from these quite interesting presentations is that the judiciary, in particular your court, will be one of the dominant player in intellectual property law in Russia. So it's a court, actually, that a specialized court that will concentrate all the different powers. And somehow this is a situation that reminds us a little bit the evolution of the field in the United States with the creation of the specialized court in 1982. Professor Dreyfus has been a quite well-known authority in that field, because she wrote a couple of papers, empirical papers, on the impact of the specialized IP court in the US, on the way intellectual property law has been framed. And maybe, Rochelle, you'd like to say a few words about this.
Sure. But every 5 years, somebody has a conference on the Federal Circuit, our patent court, and every 5 years, somebody asks me to write a paper on it. So it's now 30 years old, so I've written 6 papers. Our court was created in part to deal with a problem that had nothing to do with intellectual property. There were just too many cases in the courts of general jurisdiction, and they wanted to get some of them gone. And so they thought, what did the judges not like to hear? And they decided the judges did not like to hear patent cases, and so they created a patent court. So that was really a way to just make the other courts operate more efficiently. Now, it also had some effects in patent law that were important. Most of our cases are heard in regional courts all over the United States. So a case that starts in New York will be heard in New York. It will be appealed to the Second Circuit, which is the Court of Appeals that decides cases for New York, Connecticut, and Vermont. If it's in California, it'll go to the Ninth Circuit. And what was happening in patent law was that different courts had very different views on patents. And so people who had patents tried to get their cases into a court that loved patents, and people that were defending patent actions tried to get their cases into a court that really hated patents. So we had a lot of forum shopping, and it was creating a lot of instability within the system. Aside from that, the review of the patent office was in a special court, and that special court had nothing to do with regular patent cases. So the standards of that court were different from the standards of the regional courts, and again, it created a lot of uncertainty. So on the one hand, we had the regular trial courts being too busy for patent cases, and on the other hand, this need to try to find a way to make patent cases more efficiently decided and also decided in a more uniform way. And so in 1982, they created the Court of Appeals for the Federal Circuit. And so it was a way to create quicker decisions and also to eliminate notorious differences amongst the courts. Now, the judges of that court are selected in a variety of ways. Although the court hears only patent cases, all patent cases, it doesn't hear only patent cases. It also hears other kinds of cases. So it hears cases about export controls. It hears cases about federal contracts in general. And it has a few other areas of specific authority. Cases of labor disputes within the United States government are heard by that court. And so some of the judges had been specialized in patent law before they went on the bench, but many of the judges were specialized in these other areas, in labor law or in contract law or in export law. And so the judges are chosen from a variety of different fields. There are a few judges with expertise in specific technological areas, but the judges on the court are fairly old, which means that their expertise in technical aspects is very old too. So take organic chemistry as an example. We have two judges who are organic chemists. They both treat DNA molecules, biological molecules, as if they were organic chemistry molecules, and ignore the informational aspects of them. So the expertise of the judges is somewhat helpful. They can read documents about science, but their knowledge about current science is not very current. And so their expertise is actually quite limited. Now, how does the court work? Since we've been at it for 30 years, it's very much like by the bar. The bar in the whole feels that they know what they're getting, they know how decisions are going to come out, they understand the law as being much more certain, they can look at a patent, they have a better sense of whether it's going to be upheld or not. So on the whole, the patent bar likes the court a great deal. I think other people are a lot more skeptical about the court. A lot of the commentators are very skeptical. I think people who do competition law are rather skeptical. And most important of all, the United States Supreme Court is very skeptical. Every year it takes more and more cases from the Federal Circuit, and it tends to either reverse them outright, or even if it affirms the decision, it does it for completely different reasons from the ones that the Federal Circuit actually used. So the general feeling is that the court's quite rigid, and most important, doesn't hear enough cases in other areas to be able to judge whether a patent is actually necessary to promote innovation. So for example, it hears very few competition law cases. I'm sure that's what prompted your question. And so it says to itself, well, we must have patent law to promote innovation. They don't think about the fact that competition also promotes innovation. They have very few copyright cases, almost none. They have trademark cases that come out of the trademark office, but not trademark cases between individual parties. So they don't think about copyright and trademark as also promoting innovation. And they don't have any trade secrecy cases at all. So they tend to value patents extremely highly. And there are many people who look at the court and think that they're valuing patents much too highly, that there are other things that the economy does to produce innovation and that the court fails to consider. So the court's been successful in some aspects. Practitioners like it. I think the industries that have patents like it, but the industries where patents are problematic, they feel that the court has contributed to the problems.
Thank you very much, Rochelle. May I also add another question with regards to the balance between the USPTO and the courts in your system. There has been some quite interesting recent legislative developments in the US with regards to the USPTO. Do you think, can you explain what that consists? And maybe, if you have a thought about if that will change the balance, I mean, from a judicially type of centered system to a more regulatory somehow system?
Well, as the judge noted, usually an agency deals with the facts, and the courts give a great deal of deference to the agency so that the court doesn't have to rethink the facts. And that's true in the United States, too, for most administrative agencies. But the PTO, the Patent and Trademark Office, is a very old agency. It was founded by Thomas Jefferson, one of our very first presidents. And he didn't really think about agency law. This was something very new. Regulatory law didn't really exist at that time. And so the Patent Office's history has been that it doesn't get that same level of deference. So trial courts don't ignore the facts that were found by the Patent Office. And of course, the Court of Appeals defers to the trial court, but it also doesn't defer to the Patent Office on any issue of fact or any issue of law. So that's been our history of having no deference. But as the judge also noted, expertise in intellectual property is becoming increasingly important. And so because our judges have expertise that's very old, they're not helping very much. And so there's been a lot of talk about turning the Patent Office into a modern administrative agency and giving it more deference, the kind of deference that is normally given to agencies. We have a new patent statute that has just gone into effect. The Patent Office will have more adjudicatory authority, that is, parties who want to challenge a patent will be able to go back into the Patent Office and ask to have it challenged. And that will give the Patent Office a little more perspective on patents. And the hope is, and they've just hired an economist in the Patent Office. That's a new role. They've hired a policy person in the Patent Office. That's also a new role. And as the Patent Office increases its ability to think about policy and to do it from multiple perspectives, the thought is that it will start to get more deference, but it hasn't happened yet.
Thank you very much, Rochelle. You actually mentioned the word innovation, and somehow this is becoming right now the centerpiece for both intellectual property law and competition law regulation. And when I was, looking a little bit to the Russian system of protection of innovation, promotion of innovation, of course we have the intellectual property court, but also we have a new player, Skolkovo, that has somehow a different role in promoting innovation in Russia. And maybe, Alexei, you would like to mention a few words about how you see your role in this particular context.
Спасибо, Янис. Я хочу, на самом деле, несколько слов сказать.
Thank you very much, Yanis. I would like to tell a few words about the research, the report that was distributed to all the participants. I hope that you managed to leaf it through, and I would like to tell you, well, when you will read that, at least it will give you some answer to the question what role Skolkovo plays in developing innovation in the country, and why did we decide to start working with the intellectual property, and why we decided to research it within our own entity, and why we decided that competition is so important in the current environment. We see that there is a monopoly to intellectual property, and we believe that it should be absolute, but this point of view has not been particularly justified in both practical and theoretical ways, and this point of view leads to large social losses. It deters social development and economic development. Now, we decided to approach the whole intellectual property institute from different sides. In particular, trying to judge it from the position of the companies of Skolkovo. Skolkovo's participants are small and medium enterprises that make their first toddler steps in creating their innovative products. They get grants as a support, and also they receive various other kinds of support, such as media coverage, such as PR that helps them to reach out and tap Russian and foreign markets. And one of the ways of supporting those small and medium innovative enterprises is to try to help in amending and changing the Russian legislation to serve the best interests of these companies. Now, the reports that has been distributed showcase a research that we've made. It was a poll that we made, one of the largest in the country, during which we asked the various companies what problems they face when they would like to commercialize their intellectual property, and as a result, quite a low number of companies were complaining about the possibilities of defending or protecting their property rights, but there were complaints that you have to spend quite a lot of money, efforts, and so on and so forth to make patents and to commercialize their products. Newton actually said that I wouldn't know that much if I was not standing on the giant's shoulders. I think this describes perfectly well how different innovative sectors in Russia are developing. You require a platform. You need those solid ground to stand on, and very often we hear the criticism that intellectual property is an area where natural monopolies, or where the natural monopoly reigns, and it doesn't help in developing innovative products. So we decided to look into several examples. There is one particular example that shows the lack of dynamics in the IP protection law, and that is parallel import, ban on parallel import. I hope Igor will develop on that in more details, but what we try to research and what we try to look at, how that particular law influences the development of innovations in the country. Sorry, there was some noise in the mic. So, the only problem we touched upon is how much innovative companies suffer from that parallel import ban. The examples that are shown in the research are surprising, really. Small and medium enterprises do not have the possibility to become competitive when they have to pay 3, 4, 5, 8 times more for the products in here than if they could buy them from abroad. When they have to wait for the materials to be shipped to them 6, 10 times as long as their colleagues abroad. So it's due to the fact that the environment that these companies have to live in and to work in creates this additional load, drives their costs much higher, and doesn't let him develop. You know that the ban for parallel import in Russia, and I don't know whether you are aware of that or not, and how it is legally structured. Well, the thing is that when we were questioning our innovative companies, a lot of people did not really know about the influence of this parallel imports ban. And that's why in our book we used the following quotation from Anderson's fairy tale about the naked king, when everybody praised the king's new clothing, new dress, but there was no dress whatsoever. He was completely naked. So the same happens in here with the parallel import. There's a lot of people making comments about it. There's a lot of criticists. Somebody says that the parallel import ban works well within the WTO structure. However, there's a decree, a ruling of the Constitutional Court, 2004, that says that we prohibit the parallel import because we protect the international obligations of Russia. What kind of international obligations, we do not know. I think it's like in the Anderson's fairy tale and the story that Constitutional Court was just afraid to tell us what are the specifics of this problem, and they just pronounced something of a generic character. That's why we have put this metaphor in the book, in order to attract more attention to the problem. A lot of innovative companies did not even know about the existence of this mechanism, and I will tell a lot about that since we have enough time. There's a short story how it all appeared and what is this animal is all about. We were really lucky with our research because in March the High Court of the US heard a case about the parallel import, and it's a very interesting case because the majority of judges expressed their opinion, and there was a judge who expressed her own special opinion, Ms. Ginsburg. She had reviewed the problem from a different side, and this ruling of the court indicates that there is an argument even between the judges within one institution, and strange as it may seem for our legislators who supported the ban and for other officials who supported the ban, the High Court of US says that they never wanted to create the doctrine of first sales. The court says that this doctrine of first sales appeared as an institute that prohibits division of the market. So historically, the view of this doctrine of first sales was based on the fact that the markets where the goods land in after they're circulated in the country should not be limited in terms of the right owner had not to be limited. Well, in our case, this ban is used for an opposite principle, to limit the distribution of the goods. But Judge Ginsburg says why this doctrine has appeared. She says that there is an international policy. The government of the US, protecting its political interests, protecting its trade, was making other countries, and we can name Russia in their numbers, was making to withdraw from that principle and to take on the regional principle of limiting the rights. In 2002, a new decision was made, a new amendment was made to the trademarks law, and then it was distributed to all other intellectual property objects. Not a single document was adopted in the government or in any other expert center that would argue in economic terms this particular principle. There is no analysis that said that the national principle is needed. You will even be surprised that this amendment was introduced by the High Court of Arbitration, that is not the agent, is not the body to regulate the economy. It doesn't have the necessary instruments or measures to assess the consequences of the decision. So this decision was basically based on some legal logic. They were based upon the decision that the Institute of Intellectual Property, that pertains the territorial limitations. We believe that it's not a correct understanding of the Institute of Intellectual Right. And the model of exhausting of exclusive rights, well, when in the beginning of the 20th century this institute was established, they were thinking, the guys who created it were thinking about a different thing. They thought that the rights owner with this principle in place would not be able to limit the circulation of the goods on a certain territory. So it might sound as a national or regional principle of exhaustion of exclusive rights, but that all was just made by chance, and it was not related to any economic arguments that would be justified or that would be based on certain social demands, but it appeared because of the wrong understanding of the nature of the intellectual property. And due to this wrong understanding, we very often face a situation when the Institute of the Intellectual Property undermines basically the social development, and in many other areas it entails negative rather than positive consequences. Another example that has been discussed in here is to fully withdraw the intellectual property law from the anti-monopoly or antitrust legislation. If you have a look at the letters sent from one minister to the other, you'd see that the argument for that is very simple. It says that the nature of the Institute of Intellectual Property, it's a monopoly that has been granted by the states, or even higher than that. Please do not touch it in your antitrust or anti-monopoly law. But this thesis comes into opposition with the doctrine of exhaustion of exclusive rights, and basically we find the same problem. So our vision, the vision of Skolkovo as an institute that has been established first and foremost to promote innovations, is as follows. We see where our system opposes or comes into odds into constitutional or innovative developments. We see that there's a possibility of resolving certain problems, and these problems are not related to any deep systematic changes that have to be introduced. Actually, what we are doing is fully in line with the logic of the international community, and in accordance with this logic, we propose to remove some additional barriers and to create additional opportunities for companies to develop. And in this, we hope that Anti-Monopoly Service, FAS, will help us, because they're responsible for the competition in Russia. And we hope that the legislation will also support us. But I think you can already congratulate us with the first victory, because our government has already heard our arguments about the parallel import, and we will continue the work with prohibiting the ban on parallel import. And as for the competition and as for the intellectual property rights, I think we'll have to discuss it even further on in the next periods. Sorry for being too prolonged.
That was extremely interesting, in particular because we see here a tension between a more economic, policy-oriented type of approach and a more legalistic, I would say, type of approach that courts develop more often. I was reading lately an unpublished manuscript of a very well-known American antitrust law professor. He hasn't published it yet, so I will not say his name. And there was actually a paragraph there saying, patent law has resembled property law much more than anything could be described as industrial or innovation policy. Real property lawyers and judges deciding boundary disputes rarely address fundamental questions about how these property rights should be, how they should be distributed, or how broad their power to exclude should be. Patent law developed with complex rules of construction, developed by reference to previous case law rather than any broader base of economic or literature or empirical literature looking to particular industries. So we have actually here two patent lawyers, and I would like to ask them what is their perception about, is this really an accurate description of patent law, or are there mechanisms within patent law also to integrate and incorporate more economic analysis and industrial policy or innovation considerations? Maybe, I don't know, Rostel, you would like to mention a few words about this?
Okay. Okay. I mean, I think it's maybe a pretty accurate description of the Federal Circuit. So when I said before the Federal Circuit is quite rigid, I think that captures its notion of patents as property and as the scope being something that you can easily determine from the document and from prior cases rather than from an economic analysis of what the appropriate scope of the patent should be. So I think that actually might be a pretty accurate description of what our case law looks like. Now, whether economists think that that should be the law is, of course, quite a different issue. And there have in the past, prior to the Federal Circuit, certainly been some doctrines in patent law that did do the kind of analysis that you wanted. So one is, there's a doctrine of patent misuse. It says that if you abuse the patent and try to get more than the privilege that the patent is supposed to provide to you, then the patent is not enforceable. So that was a doctrine for a very long time. It's one of the things that the Federal Circuit has more or less gotten rid of. You see very few patent misuse cases now, but many people think it should come back. There's a research exemption, or there, in most countries and traditionally in the United States, there was a research exemption. What's the research exemption? The research exemption says even if you're doing certain patented acts, if you're doing it for research purposes, to push the frontiers of knowledge forward, to learn more about the patented invention, to figure out new things to do with the patented invention, to improve upon the patented invention, then you are not an infringer. You're not liable for infringement liability. And you could think of that in an economic way, too. You could say that the social benefit of doing this work is so much higher than the private benefit of allowing other people to stop it that you would want to have a research exemption. So many countries and prior to the Federal Circuit, the United States had a strong research exemption, and that also narrowed the scope of the patent in favor of the public interest, in favor of the kind of companies that Skolkovo is thinking about, companies that want to enter the market and need to build upon the shoulders of giants. The first sale doctrine, the patent exhaustion, in the international context, parallel imports, very much the same thing. And now we're going to see this fight between the Federal Circuit and the Supreme Court. The Federal Circuit thinks that there should be a ban on parallel imports. The Supreme Court, as we just saw in a copyright case, thinks not. So we'll have a question: can the Federal Circuit convince the Supreme Court that the rule for copyright should not apply to patents? We don't know how that's going to come out. Many countries have compulsory licensing provisions, or provisions that say that a patentee can't withhold permission to practice the patent if it's unreasonable to do so and if it prevents products that the public wants from developing. We have never had compulsory licensing in the United States, but many other countries do have compulsory licensing. And then there's remedies. So sometimes, even if a patent is infringed, the court can refuse to grant an injunction to stop the infringer on the ground that there are important social purposes that the infringer is fulfilling, and we don't want what he's doing to be stopped. And instead, there might be monetary damages, but they might be a lot less than the patentee would like to have. So there are a bunch of doctrines in patent law that do serve some of those functions, but they go up and down. The Federal Circuit likes patents, you see less of them. A court is more skeptical about patents, you see more of them.
Thank you very much, Russell. Would you like to judge Nosova?
I would like to make a brief comment on the discussion that we heard right now. So, in this environment, when we speak about the parallel input, there are a number of four arguments, and now I'm in a very complex situation. I would like to ask a question to a Skolkovo representative. There are a variety of documents that are offered, and in this shop, this dispute, there are no right and wrong people. Usually when the positions are so controversial, the truth is somewhere in the middle. So acknowledging all the arguments that you have given in favor of the parallel import, I still want to say that the problem should not be resolved by the way of full permission. And I think that we should take into account only the current challenges. Why I am so cautious? Because there are opposite studies, and I can refer to a study called Intellectual Property and Business done by International Trade of Chamber and Commerce, and they're very cautious in their recommendations on parallel import. They say that there is a strong opposition against parallel import, but still there are more supporters to the maintenance of the national exhaustion of rights rather than supporters to the international exhaustion of rights. So this is the opinion of a business community. So, I don't want the legislator to support just one side. Maybe it's my judicial background speaks on my behalf. I was and I am a judge, and I want to take into account the position of both sides. So I would rather support a a wider view, a broader approach. Well, thank you very much. I'm sorry. Maybe I was too strong, but to make the pendulum move, you have to push it strongly on one side. But you see, the advocates of prohibition were less obvious than the advocates of withdrawal of this prohibition. Because there are really, let's say, cries and yelling from our medium company who are overpaying several times and waiting for weeks and months to get some chemical agents, and etc., etc. So that's the situation. What we saw, how we saw it, and that's why we wanted to attract the attention. Actually, we are speaking instead of those people who are displeased. On the other hand, the International Chamber of Commerce and other business associations, they are mainly speaking on behalf of the right holders because they are profiting from this situation. And of course, they are willing to sell their goods at higher prices, not to rush with the delivery. So let's say, like any monopolist, they don't like competition. So it's a paradigm which is preferential for a monopoly company. But we are not criticizing at a particular political decision. We rather want to understand the processes behind decision making. So any political decision should be easier to understand, and it should be clear which groups are supporting this political decision. Well, a parallel import doesn't have this clear background, clear structure. Until recently, the advocates of intellectual property prohibition mentioned the following. Well, intellectual property is a property, underlying the word property. Property is a monopoly granted by government and let the holder the right, or give the holder the right to use it the way it likes. So if the right holder wants to sell it, let him sell it. If he doesn't want, no. It can put any regional, national or international limitations. So this position is not based on pluses and minuses for the economy or for the society, but on the fetishism on the property. So let's say there is, the only thing, let's say, don't touch my property, but it's like a guinea pig. It's not a genie and it's not a pig in the long run. The same it can be said about the intellectual property. It's not intellectual and it's not a property. So what's the intellectual property is behind the trademark, except for making your goods and services recognizable? So the word property was derived from the old times when the circulation of products was linked to property. That's why we just inherited this old name, this old notion, and added the word intellectual. But we should not start from the notion, from the definition, and define the characteristics. We should rather adapt it to the current environment. If the antitrust service has, let's say, the right to restrict the use of monopolistic services. So if we speak about the owner of a gas pipe line, it is the owner, but the antitrust legislation forces this company to allow the access of other companies. So if we can do it about the tangible property, why we cannot do it against intangible property? So what we don't understand, and what is not clear for us, are the arguments, are the background thinking for this approach. So we don't insist on a single approach. We want to have a good understanding of both approaches.
Certainly raises a number of questions. Andrei, that would like to intervene. Let me also say that this is a debate that we also have in Europe quite a lot. We have a regional exhaustion principle, and there are a lot of different issues that one might say. I mean, you know, exhaustion in trademark might be different than exhaustion in patent. And also, you know, who is benefiting from it is not always true that final consumers do. Sometimes intermediaries do as well, and it depends on the sector. So I mean, but what I think is quite interesting is this emphasis on the effects and on social science perspective on things. And maybe Andrei would like to have a word about this.
Спасибо. На самом деле, я хотел начать с провокационного вопроса Алексею. Мы почему-то...
I would like to start with a kind of a provocative question to Alexei. For weird reason, we started to discuss intellectual property from the parallel export. And it may seem that all features and challenges of intellectual property are limited to parallel export. I have a ready-made presentation. I would like to ask our engineers to download it if possible, because but well, before I move to my presentation, there is an exact proposal how to mitigate the issue of parallel import. if we move from de facto from the administrative control to the monitoring of the national exhaustion of rights, so if we move from that to the situation when the right holder in its agreements will limit the rights and any violation will be contested in the court. So if the right holder able to convince judges that there was a violation, he is lucky. If not, pity for him. And in this case, the right holder doesn't lose anything because the taxpayers cover the rights of the right holder. But we shouldn't abuse the position of the right holder. So one of the tools, one of the instruments is to put an extra burden on the judicial system.
I was thinking actually that to probably open the floor to some questions concerning the issue of parallel imports, because I think it's actually intellectual property law doctrine trade interaction, and I was thinking of moving to competition law a little bit later with President Artemiev. Yes, before that.
Я просто когда предполагал.
Well, when I planned my presentation, I also wanted to speak about the parallel import. Of course, it's a compromise. For the production facilities localized in Russia, this regime of parallel import should not become more liberal. So if a Ford company builds a plant here, we as Russia can prohibit the parallel imports of Ford products manufactured elsewhere, and this model will protect the existing investments and will maintain the favorable investment climate. But in all other cases, I don't see any objective reasons for keeping the parallel import prohibitions so strict. We have a number of cases when we want to support the initiatives of our domestic businessmen who should be able to come to any country to buy any product legally put into the circulation in this country and bring it back home, because otherwise it's a very severe violation of free trade principles. In particular, when we speak about the cases when competition is still there, I call it personally as a banana republic regime. And all the arguments that we hear that the storage conditions will be bad or improper or there will be a misuse, these are just pretexts. Today, the government and Igor Shuvalov in particular supported FAS, and it's not clear for me why in Russia it's FAS who is the initiator of this issue. Well, for EU, it was mainly EU-US relations that and these mechanisms were to protect the European business, but it doesn't apply to us. Well, the government decided that the negotiations with the right holders should go on, and the government will try to find a compromise. We, as antitrust agents, we shall not wait till this discussion is over. We should prefer to act. If let's say assume the right holder approve the purchase of one badge and refuse the purchase of another badge, is it not a violation of competition because the right holder is a monopolist, so it's his preferential right and preferential choice? So we shall not tolerate this position, and with all our respect to right holders, we should rather think about our consumers. So why the right holders are the center of the universe for us, and why we are still imposing different bans and limitations. I would suggest to put the consumer and the social benefits as a cornerstone for our thinking. If I legally purchased and I legally sold, what's the violation?
Of questions, but before that, let me pass it to Frédéric Génie, who hasn't spoken until now. Maybe he has some comments, and then Rochelle, and then we pass the floor. Yeah.
I have a very small comment on a very touchy issue, which is the issue of parallel imports. Two small comments. One of them is that the same issues come up in many different countries. So therefore, there have been many economic studies on the benefits, the cost of parallel imports, with very diverging results, to be honest. I mean, the first study I'm aware of was the case of Australia, where the ACCC had a very strong stand against parallel imports. More recently, in 2004, 2005, the issue came up in Switzerland, and there was a determination both by economists that the benefit of eliminating the prohibition of parallel import would actually bring very few benefits to Switzerland, and that therefore it was not worth doing it because, I mean, there was a tiny bit of benefit, but it was so limited that it was not worth it. But so I'm just saying that one has to go precisely into the situation of each country to know whether the benefit. Second thing, which is an issue of methodology, when we try to assess the benefits or the costs of parallel imports, I think there are three types of consideration that one should have in mind. First, are we interested in the consumer welfare, or are we interested in total welfare? Because we may get different results. If elimination of parallel imports, for example, decrease the price, that's good for consumers. Maybe it's not going to be good for the producers of some of the goods who are going to face more competition. And okay, so we have to. The second is whether we're thinking about the static or the dynamic, because if there is an impact on the incentive to innovate, that may be a cost that has to be taken into account compared to the benefit of having more competition, and of course, the third one is whether we think at it in terms of the domestic country or in a more global term, whether we should have a unified system, for example, on, okay. So one gets different results, not only because the objective situation of different countries is not the same, but also because there's a little bit of looseness in what we take into consideration. And I think that having a clear methodology and the clear thinking about whether we want to, it's entirely understandable that competition authorities, which are primarily interested in consumer welfare, should indeed think that in general there should be a freer trade and less restrictions. It's entirely understandable that economists who may be more interested in total welfare and also in global welfare may be more reserved about the, okay. So I think that those things we should keep in mind when we talk about this issue of parallel import and make it very clear what we take into consideration and what we do not take into consideration.
Just one moment. Rochelle would like to make a comment. Would like also to move the floor, and then we will come back again. Rochelle?
Yeah, this is also on Australia, which has been doing a lot of studies on this. So after the U.S. case, people have started to look at Australia actually rather carefully, and they have a different compromise from the one that you suggested. Their compromise is that as long as the right holder makes enough goods available to the local market, then there is a restriction on parallel imports. But as soon as the right holder stops making available a reasonable amount, now what's reasonable, of course, is a hard question, but that's the way they look at it. As long as the market is being served, no parallel imports, but if the market's not being served, then parallel imports can come in. And I think that's an interesting way to think about it.
Just one question, Rochelle. Will you characterize Australia as being an international exhaustion type of regime?
Yeah, I'm talking about the international rule. Yeah, the
exhaustion.
national rule, I think, is that there's a first sale doctrine. And this is only in copyrights. I don't know what their patent rule is.
Sure. There were some questions, I think, from the floor, so it's a time to ask them. May I ask you also to disclose who you are and who you are representing as well? It's good to know. Anyone would like to? Yes, please. Oh, sorry. First and next.
My name is Natalia Zolotych, Vice President Opora России, and I'm responsible for the intellectual property and innovation development in this organization. Opora России is the largest SME supporting enterprise and association, and we'll work a lot with federal authorities, in particular with the Federal Anti-Monopolist Service. Thanks a lot for the research that you've done. But for us, it came out as a surprise because we were not familiar with the data, and with great pleasure, I will research the report. Now, our approach to parallel import is a little bit more cautious. We have already provided and presented our proposal. Well, to my mind, what is really important in this area, when we talk about the fact that something is supplied, some products are supplied to a country, in particular high-tech products, evidently there is a risk that third parties' rights can be violated. And we not only mean trademarks in this regard. In this case, it's quite easy to see whether there's a violation or infringement during the check. What other problems may arise when you want to find out whether any patent rights have been violated. The producer usually guarantees during the sales operation that he is responsible for all the possible reclamations from the third parties. Well, if that is the case, it's one thing. But if there is a limitation or restriction of parallel imports by other companies, non-sanctioned, the question is who will bear the responsibility in case the third party's rights will be argued. And the questions of parallel import are extremely important to my mind. But in accordance with our understanding, as well as we see small and medium enterprises, the parallel imports are not the main one. These questions of parallel imports are not the main one when we talk about the development of competition and when we talk about the protection of and different innovative activities. I'd like to say that our antitrust legislation is making its first steps towards providing the rights of intellectual property, not by that we mean patents. Today we do have utility models, we have industrial models and patents and so on and so forth, but today we face a situation when the right holders, for example, for patents on utility models, very often serve as illegal competitors, and it is evident that when a patent for utility model is issued, nobody does any check, at least in reality. Very often companies come to us, the right holders, that cannot sell their products in Russia because somebody has got a patent for a utility model which is quite easy to attain because no expert reviews are being carried out for that, but it is really hard, in accordance with the criteria that we have, to stop or to seize the utility model patent. The law number 214, in particular Article 2, only explains about the means of individualization, but very often our experience shows that trademark is registered and in parallel another person, another entity registers the same trademark and industrial model. So in this field there's still a lot of untrodden ground, so to say. There's so many things that are not yet regulated by our legislation, and that is why our business and the companies face serious problems. And I'm talking only about a small share of the things that we wanted to present today. We have written a letter to Mr. Shavalov, and our proposal was also elaborated in there. I can talk about that later if you'd be interested, but for us, I think it is extremely important to differentiate between the utility model, industrial model, and the patent. Do you think, my question, that we need to introduce special regulating bodies in order to avoid any unfair competition, in order to ensure fair competition and the protection of intellectual property rights, in order to ensure that the innovation companies are developing?
Second question, because I think you had one, very brief if possible, and then I will back again to the floor.
Антон Рогачевский, пивоваренная компания.
Anton Rogachevsky, the Baltica Brewing Company. Actually, parallel import topic is an internal one. And I think a good illustration of that was made by our guest from the United States, that even in one country, the US, there is a whole variety of opinions about the parallel import. And the compromise that Igor has just told us about is not only a good balance, but it's a bright example of how to protect both the right holder and, second, how to ensure that there is enough tools or measures that will stimulate more business and more innovation. So not by doing replacement of imported goods, but my practical commentary is as follows. Considering the integration processes that are currently seen in the Customs Union, in the Europe and Asia Committee, we want these partners to be synchronized in their efforts with the work that the Russian Union does, the Russian Federation does, so that we are not isolated, like, for example, the European Union is in some of areas. And now, for the unfair competition, probably we may only wish that the article number 14 of the antitrust law is made more stringent, and that it should be tied in with the criminal law, in particular article number 178. I think that in such a way we'll be able to counteract some very threatening things.
I actually would like to ask if someone from the floor would like to comment on these questions. Alexei?
Очень кратко постараюсь.
Very briefly, just a couple of points. I would like to react to what Professor Genie has said about the methods of researching the effects of the parallel import, and I would like to react to the two questions that were asked in here. Now, the problem of the parallel import is not the only one. within this whole topic of interface between IP rights and competition. Why we're talking about the parallel import? Because it helps us to really shed some light on the overall problematics, the problematics of interface between the IP Institute and the competition. And in order to launch the discussion, you need a stimulus. And this topic, the parallel import, is it serves as a ram that you crush against the gates in order to enter the castle. But today we see that there is a problem of relations between patent protection and competition, and very often we face it when we talk to different resident companies of Skolkovo who want to tap foreign markets. We often hear that the US patent law in relation to software is very unfavorable for Russian companies. This famous trolling of Apple against Samsung, and that is very scary for small startups. And since the US market is so wide and so attractive for the software vendors and developers, definitely they're very interested in resolving this issue in a more positive way, so to say, for the startups, so that the more fair competition is ensured with less costs for the business itself. Now, we're coming back to the issue of methodology that was touched upon by Professor Genie. In this case, we need to really understand why are we regulating these or those relationships, for which particular purpose and which paradigm do we use? Is that a value paradigm or an instrumental paradigm? And in what kind of institutional environment are we acting? When the ban on parallel import was adopted, it was adopted without taking into consideration any global interests. The interests that were taken into account is of a very limited circle or a very limited community. For example, foreign right holders, large right holders that sell their products into Russia. And it's a very clear calculus, because from one side you have, from one cup of the weight, you have the interest of the Russian business, and from the other, the international business. We didn't do the research for all Russian companies. We're just responsible for our own sector. And in this sector, we see that there are companies who are not quite happy with the parallel import regime. When we assess this parallel import regime, we stem from the needs of the Russian society. Now, if we have a look at it in a more global way, then we need to really balance a lot of things. We need to understand how Russia's economy stands globally. How does our system of benefits distribution is working, and we're ready to meet the challenge. And in our research, we bring in the quotation of Mr. Stiglitz, who said that globalization is one of the most important issues of today, and intellectual property is one of the most important issues and questions of globalization, especially taking into account how the world is moving towards the economy of knowledge. The way we regulate and manage access towards the economy of knowledge has a great significance for the new economy. At stake here are both the questions of distributing the benefits and distributing the knowledge. And on the global level, this is an instrument of redistributing the wealth and distributing the profit. And however, in here we face another question, that the competition on the global level is not that well protected. Today, a very powerful tool has been proposed, TRIPS. In the WTO framework, this tool is very effective. It helps to disseminate the protection regime for our right holders, but apart from that, there are no other consolidated global tools for protecting the competition. So global cartels, global dominating companies that use intellectual properties, they act in a free from regulation and antitrust free environments or of economic domain, and we cannot serve to the interests of global influence groups when we ban parallel import. On the other hand, we understand that we cannot balance those influential groups, and we cannot provide our Russian innovative small and medium enterprises enough protection to work in this global welfare picture. That's why we focus mainly on our known national story, on our known national law, and we focus on the interests of the Russian economy. As already has been said, Russian consumers are within our attention, and it's already enough, because if we give the way for Russian small and medium enterprises to develop, if we give them the leverage to go forward, that will already be serving the purpose of our foundation.
I think we will obviously touch upon the issue of the global balance, and I think Fred also mentioned that before. But before that, I think it would be quite interesting to focus on the way Russian competition law might apply concerning intellectual property law issues. And I would like to ask President Artemiev to answer a little bit his view, and share his view about the way competition law will apply in intellectual property disputes in Russia.
Well, thank you very much. I would like to show 3 slides at once. Well, to look wiser, I would like to make a small comparison. If we look at any monopoly, including intellectual monopoly, and compare it to the ways how nature resolves these monopolistic issues, we can see very surprising results. In living nature, monopolists exist for a very short time, because otherwise they are just destroyed completely by the forces of nature, because this diversity is the best protection against monopoly. So let's say any holder, any bearer will be completely destroyed and eliminated if it occupies the monopolistic position for a certain noticeable period of time. Society would like to take into account the public benefits when monopoly is established, and the society will never agree to some outrageous restrictions. And if an inventor of a drug who save kids or who can defeat cancer will for some reasons refuse to produce it, the society will force to get this drug. So there must be some efficient mechanisms for the antitrust measures. And only human beings, because we have brains, we have rules, somehow manage to protect the right holders who behave like misanthropes. Otherwise, in living nature, nobody will be so protective. I shall not come back again to the parallel import, but in general, the antitrust legislation must be incorporated into this sphere, but it should be done gradually, slowly, and very gently. The legislation must give the exhaustive list of cases when the antitrust legislation can be useful. So we are not speaking about any confiscation of rights. We are speaking about the sale of patents. And slide number 3. What we believe to be the world best practices are well-established and known facts. We are not speaking about something new and unknown. In TRIPS, we have clauses against antitrust. We also have the antitrust guidelines for the licensing of intellectual property. We do admire Japanese relevant legislation, and the Japanese Act says straightforwardly, that nobody can ever prohibit a parallel import. Well, I would like to copy this phrase from Japanese legislation, though I will not be allowed to. So, slide number 4. What are our proposals? I have already mentioned this option, but this weapon should be handled with care, because the right holder or the exclusive dealer is 100% monopolist on our market. It means that he is subject to the antitrust legislation, starting from the extremely high price or preferential agents, and the penalties, the sanctions are rather heavy. So we want to apply this legislation because we know hundreds of cases when dealers are selling the products at a price which is 2, 3, 5 times higher than on the European or US market. We shall not tolerate, and we do not tolerate these cases. Today they are rather exceptional, and it's because we know that intellectual property issues are so fragile and tangible for the right holders that we should be very careful. But I think that it's right time to make some showcases, at least for pharmaceuticals. Particularly when we speak about drugs for patients with rare diseases, and this is done by Big Pharma, who is explaining that they are sponsoring and they are donating quite a lot. And I think that in this case, we will just follow the social demand if we would be more strict against such excessive overpricing. And the same is true for licensing agreement. We don't want any restrictive measures because the right holders tend to give just bits and pieces, retaining codes or essential equipment, and what's the use of such a license agreement if you cannot use this license in the long run? And we want our antitrust legislation to prevent the execution of such license agreement. Well, the topic of the forced patent is available. I don't remember the case when it was ever applied.
Issues with regard to the way competition law might apply ex post, somehow as a corrective to the abuse of intellectual property rights, but also any intervention from the point of view of a competition authority faces also the risks of error, and obviously in particular the situation of excessive pricing regulation is pretty an important example and a difficult example of antitrust intervention. I would like probably to ask Frederick if he has any comments on the excessive pricing issue, and in particular on the way antitrust and intellectual property interact.
Yes, less on the excessive pricing issue, but maybe more speaking from the point of view of the work that we've done in the Competition Committee at OECD on the increasing tension between competition law and international property law and what that leads to. And I think that it's important to, I mean, we have been looking at this issue for the last 15 years. We've organized many roundtables among competition authorities, so it's a view from competition authorities, of course, on intellectual property rights, innovation, patent, and competition over time. And what has clearly happened over time is that there has been more and more tension developing between the two fields of intellectual property and competition. And there are good reasons for that at different levels. One of the reasons has been alluded to by Mr. Artemiev, which is the fact that any law has to be socially acceptable to be useful. And intellectual property, in a sense, has become less and less acceptable politically in certain areas. And I'll give you two examples. One of them is what happened just after the signature of the TRIPS agreement. In the developing countries, within 5 years, you had a lot of countries that were affected with the AIDS crisis. And they realized that they had signed a commitment that they would not make generic a product without the authorization of the manufacturers of the principes. And that created for them an impossible dilemma because this TRIPS agreement was actually killing people on their streets. Okay, so there was a renegotiation, but it was clear that right from this moment in developing countries, a lot of countries said, well, the values that are behind trade and freedom of trade may be mitigated by other value, like humanism, like defending your own people. The financial and economic crisis has had pretty much the same impact in a number of developed countries where health systems are unable to face the cost of princip medicine, and where it becomes less and less acceptable that they cannot deliver on the promise of maintaining people in health. And again, there, for the same reason, maybe less, in a sense, less stunning, but equally important, the idea that intellectual property rights have to be defended all the time, that compulsory licensing is unacceptable, becomes less and less politically acceptable. Okay. One thing. The second thing, of course, has been the development of globalization, and that has been the tremendous increase in countries that had competition law. So therefore, many more countries experienced the interface between competition law and intellectual property right. But globalization not only increased competition law throughout the world and the ability of competition authorities to be faced with some of the problems that we've talked about, but it has also made the system of patents less and less manageable because it has increased considerably the number of requests for patents. It has increased the delays for a patent to be granted. It has allowed the development of a large number of strategies by firms to use the difficulties in the administration of the patent system for anti-competitive purposes. And one example of this has been that during the last meeting that we had at OECD, which was 2 years ago on this issue, the European Patent Office came to us and said, look, I see terrible things happening as a patent office. I see firms being completely strategic in the way they claim patents. They know perfectly well that they are not going to get them in the end, but they know that it's going to take us 5 years to say that. And during those 5 years, they can threaten competitors with the fact that if they are successful, because the patent will be granted from the original time of the request, they are exposing themselves to huge risk. And this, I mean, this is small examples, but there are numerous examples of this. So the second thing is that globalization has made the issue more frequent and more unmanageable. The third dimension is the fact that economists know very little about how innovation is produced, but are more and more skeptical of the fact that a global intellectual property regime, as opposed to sectoral regimes, is such a useful thing to promote innovation. And we've been struggling at OECD with three questions. The first one was, what's the relationship between competition and innovation? Does competition promote innovation, or does lack of competition promote innovation? And you know that economists have had different theories about this. So the answer is that it depends. The second question has been, does the patent system promote innovation or reduce innovation by blocking innovation from others? Look at the mobile telephony sector. I mean, do we actually believe that all those patents are good for innovation in the sector, or they are all attempts to prevent others from innovating? Okay. So the answer is, we don't know whether the patent system actually globally promotes innovation or not. It depends. It may also depend on the sector. There are sectors where you don't need you don't need a patent to promote innovation because you want to be the first on the market. If you get a patent, it's on top of, in fact, the actual benefit. So all this depends on the sector. It depends on the circumstances. It depends on the type of products that one is talking about. But clearly, it's not obvious that in all sectors, the patent system is good for innovation. And the last issue that we looked at was whether patent promotes competition or not. And again, you can say, well, yeah, they do, because they bring to the market new products, which are then competing with the existing products, and that's good. And you can, and we've also already given examples of cases where it reduces competition. The end story of all this is that we know very little about how all of this works. And the economists are not very well able to give clear lines on how the system should be fixed. Okay? But you look at the best research on innovations, what were the origin of innovation, how did they come about, was it the patent system that promoted them or others? There's very little evidence that at the macroeconomic level, the patent system has really helped. Okay, so we've got a broken system. We have a system which is less acceptable than it was a few years ago. And we have a lot of uncertainty on whether it is a justified system. For all those reasons, competition authorities have been saying, we want to have a say, or we want to rethink this whole issue. And there have been several lines that have been followed. First question is whether we should not have sectoral intellectual property systems. In other words, different principles for different sectors, depending on whether we are in a sector where, for example, innovations are mostly innovations of completely new processes or product, or sectors where you have incremental innovation. Okay, so it's not obvious that when somebody takes somebody's innovation and then improves the innovation, and then like in biotechnologies, for example, or in computer science, you need the same kind of intellectual property system as you need in, I don't know, for steel making or for sectors like that. First question. Second question, should the system be administered in conjunction by competition authorities and patent offices? In other words, if the definition of how wide the patents are is going to make a difference in both innovation and competition, it's very often too late. I mean, I've got the utmost respect for the intellectual property courts, but the intellectual property courts we've heard have a very difficult task coming ex post and trying to fix the system, because originally the patents were given in a way which maybe was unwise from the point of view of what is one should look at. Third dimension is when we think about competition and intellectual property, they are quite different on two grounds. A, there is a general agreement that we've already referred to on intellectual property, which is the TRIPS agreement. There's no equivalent for competition. But B, competition is administered in all countries on the basis of what we call the effects analysis. Before deciding that a practice is anti-competitive, a violation of the competition law, we look at, does it actually reduce competition? This is not the standard which is used in patent law. We've heard that there is tension in that direction. But overall, it's a more formalistic approach. And again, if I come back to the mobile telephony sector, what's happening now between Samsung, Apple, and everybody else, I think that there's a lot of formalistic approach without the courts or without the laws requiring that the courts look at whether it promotes innovation, the behavior promotes innovation, or whether it restricts innovation. The approach is more whether there's been an infringement, and then I don't want to know whether this promotes or doesn't promote innovation. If there's an infringement, that's it. So looking at the principle on which the patent law is administered, bringing together competition authorities and patent authorities ab initio to try to fix the system of patent systems, and probably moving trying to get a general agreement on competition, that would be, of course, also part of the agenda, is what we are moving towards, at least when we think as competition authorities, with the help of patent offices, as where we should go.
Thank you very much, Frederick. You raised quite a number of questions. I will identify three that I would like to ask the different participants to comment upon. The first one is the economic analysis of intellectual property rights, and I will invite Andrei to comment on this particular issue because he worked with this impact assessment of the IP system in Russia and the interaction between IP and competition from that perspective. Then the issue of the sector-specific IP rights. Should we have, a sector-specific IP regime? Is software the same than biotechnology? Do they need patents the same? Should we interpret the rules the same way? And I will invite Jasna Vselova to comment on this in Russia as well. And the third issue is the interaction of institutions. I mean, the cooperation between institutions, between the intellectual property offices and the competition authorities. And to that, I will invite the different participants to comment upon, as well as Bill Kovacic, who will be intervening through video later. So let's start with Andrei first, and the economics in intellectual property law and innovation.
Спасибо. Верните, пожалуйста, презентацию.
May I ask you to put on my presentation once again?
And please let us have a look at slide number 3. In order to save your time, I would like to... is that me who have to manage the pointer? Okay, slide number 3. Actually, the IP rights problem fits very nicely to the concept by Douglas North, who counted only 2 economic revolutions in the history of mankind. First, when the property rights appeared or were formed, and the second one, when the intellectual property rights became to be institutionalized. That's why when we talk about the intellectual property, we should not forget that we are currently at a stage when where it is very hard to include the intellectual property rights into the whole system of business transactions, ensuring the economic growth, because the history shows that the sustainable economic growth only dates back to 200 to 250 years, and this is a theme that only covers just a couple of dozen countries. And that's basically related to the usage of the intellectual achievements, and it so happened that nothing is that simple. And I have given a very short list of authors who have dealt with the issues of intellectual property and the economy behind it. And they have also dealt with the issues of intellectual property rights and competition, and I can only call such names as Machlo, Perot, Nordhaus, well, those of you who don't know them. But it so happened that the theory of economics doesn't have a consensus, or it doesn't elaborate how the IPR is connected to innovations, what is the interface between IPR and competition, and there's been an article written by 5 authors that shows that all along this growth of competition, at first the intensity of innovation grows, and then after reaching a certain maximum, even though the competition goes up, it still goes down. But empirically, it is very problematic to measure that. Post factum, yes, but when the decision making is required, those modern methods of empirical analysis do not allow you to do that calculation or that forecast. Now I'd like to turn to the issue of the economy of balancing antitrust and intellectual property rights protection. I will try to focus on Russia. We know that there is a problem of global compromise when there are global intellectual property rights that are protected, but there's no global anti-monopoly policy. When we tried to resolve that issue last year, we even have an article about that. It happened, it turned out that the chances that this global anti-monopoly policy will appear are very meager, because that clearly sits into the very known model. And I would like now to continue with the national level. And I would like to refer to the following issue: whether to extend antitrust bans on IPR in Russian Federation or not, or shall we wait? And we are talking not about Article number 14, but basically Article 10 and 11 of the Federal Law on Competition Protection, which were touched upon only briefly, but I would like to show in more details that the changes that from the first sight seem to be improving the whole situation, improving the health of those patients that suffer from the lack of medicine, or suffering from the lack of the products that should be produced by implementing the results of the intellectual activity. Well, the story goes like that. When we want to gain short-term results, we should always remember that there's other time frame. Together with Mr. Ivanov, we are citing the similar sources, and we all know that there is a problem of violating the rights on the results of intellectual activities, and the document that has been prepared by the Federal Anti-Monopoly Committee to the Ministry of Justice elaborates 4 groups of those violations. But what's more important is that all those problems are being dealt with through the lens of the rule of reason. It's a critical approach that can be applied when reviewing such rights as to the results of intellectual activity and so on. So the requirements for enforcement infrastructure should be discussed, standards of data collection and processing, and standards of information received interpretation. But basically we're talking about economic modeling. What kind of models shall we use for interpreting the data? And we need to know what we get at the end, either the increase of the total sums or a much less positive result. There's been a couple of other cases in the US, for example, Kodak, when it was fined, and a similar case was with Xerox, when the company was not found guilty. And an interesting point here is that to know whether the company managed to go out of the exclusive rights or stay within them, and Xerox managed to do that, and it's one of the situation. Well, in those areas where we deal with exclusive rights, everything happens quite differently as opposed to those areas where we talk about normal types of goods. Now, coming back to an issue, what shall we do with the IPRs, with the IPR in Russia? There's not a simple answer, yes or no. Whether we should exclude those exceptions or we shall leave them be for eternity. Both answers would prove wrong. In case if we remove the exceptions, we will get a lot of type 1 mistakes or errors, and if we will drag it along the eternity, we'll just forget about the problem. It might be that we'll face type 2 errors when intellectual property rights will be used even against the benefits of the competition. So with this, we have another question. What we show now is a long-term perspective, but what shall we do today? And here we disagree a little bit with our colleagues who did the project, and I would like to note to you that in this research you will find a lot of difference of opinions. What is written in here is not a single position. If you read it carefully, you will see that some of the opinions might differ, and when we discussed the question whether we need to make the single opinion or the single position, we found out that it is not possible because the current level of knowledge does not allow us to do that. So when we speak about, well, in brief, I would like to show that we wanted to show the diversity of opinions to different problems in order to initiate a discussion. So that was done conscientiously and for a reason. Why am I insisting on the thing that we should not touch Article 10 and Article 11 of the law? It is clear that the IPR in Russia is not protected that well. In some of the areas, pirates are becoming wealthier, but to my mind that's not the main problem. The main problem is the model of Russian antitrust law. We are not talking about that in relation to intellectual property, but to my mind it is very important. And I would like to come to another slide that I have called in the following way. If we want to get everything and now, it means that we will get nothing and gradually. So I mean, if we will just eliminate Article 10 and Article 11 of the law, we won't get anywhere on this way. In order to answer the question whether there will be any positive outcomes of cancelling these exceptions, we need to really get to know how antitrust bans are implemented in the other market. And there are best practices available all over the globe. Well, probably we could have taken the EU laws because there are no exceptions for the property right, but intellectual property right. But I can say to you that those economists who deal with market transformation problems, they have taught a lot from the import institutes. There's a theory that says that if we bans all the rules from abroad, the life will go the same way in this country. Well, it won't. Privatization that happened 20 years ago have shown to us that nothing of that kind works. And in relation to that, I would like to mention and to bring to your attention that there's a couple of descriptions. No offense taken, please. I'd like to say that in the Russian antitrust law, the balance between protection measures of the competition policy and the active measures of the competition policy are not balanced. FAS has only a very limited relation to that because it's outside our competence, or at least it's not under our jurisdiction. The following thing occurred: the creeping regulatism. Anti-monopoly body starts doing more and more economic regulations, and that entails and that involves different mechanisms. For example, high price monopoly. do you think it's such an easy question? If we just withdraw from comparable markets and we just use the costing method when assessing the monopoly high price, well, we can spread our hands and say we cannot do anything. There's a very short way up to economic regulations. Now, regulated trade practices that are discussed quite often, and very often companies are very happy that finally they will find this calm haven where they will be able to resolve their problems. But it is also an economic regulation domain. And now, trading at stock exchanges. That's another topic, and collective domination is yet another topic. Let's take the European Union. Well, we don't look into the United States here, but in the European Union, they control the deals that bring to economic concentration. If you have a look at this particular norm and how it is applied in Russia, it's okay if such norms could only be applied for the oil and gas companies, because that's for whom the norms were drafted. And several years ago, when the norms were implemented, it was voiced that this norm would not be widely spread. But my colleagues had a look at that, and it so happened that 200 cases in different industries and in different areas that deal with the problem of collective domination in the courts, and we have a very difficult form of interpretation. Any business can individually violate the laws being a part of the collectively dominating entities, and that's a very unique construct, so to say. But now try to extrapolate the following situation. When we erase Article 10 or Article 11, where there are 4 competing companies with their own brands, and there are other companies appearing who start blackmailing those right holders, and they start asking them to work with their brands to use the requirements that are currently prescribed in the law will not lead us anywhere, because that's what we mean by exposing unfair requirements. And I had been participating in a lot of disputes of that kind. And there's another disease that had already passed that the US and the EU were really ill with. That's the non-hospitable model in antitrust, when certain economic theories are being used that are very hostile to certain commercial practices, for example, limiting the possibility of choice for a business partner. Now, that works in full. That is currently in full swing in Russia. So I would be fully in favor of extending the range of anti-monopoly or antitrust bans for intellectual property rights. Understanding and appreciating that we lose something in here, but that's where the main problem sits. And there's another thing, and I believe it's a systematic thing. We're talking about administrative system and its activities. We have compulsory licenses, we have civil legal relations, and we could say, please go into court, but anti-monopoly or antitrust bodies are constructed in such a way that there is a legal entity, there is a business entity who complains to the anti-monopoly authority, and the anti-monopoly authority must react to that claim or to that complaint. Mainly they will just make a court case, but for the claimant, for the complaining party, it doesn't cost anything to refer to the anti-monopoly service, and fair right holders and decent right holders would have to constantly fight back and combat such companies. And in order to avoid that, something has to be made in the administrative code or to provide something within the civil code, for example, through the mechanism of compulsory licensing. Otherwise, we will end up with a so-called Cobra effect. When the actions aimed at achieving certain targets originally, or at the first sight, lead to certain achievements, but later do a very different thing. The thing is that why I'm referring to cobras, that's the story of the Indian village when those cobras, in order to reduce all those cobras, everybody started collecting them, but finally they just breeded more cobras. And what are the set of risks that we have today? We need to understand what's the difference between the exchanges that happen in the intellectual property rights sphere and how we're different from the foreign analogs, because I haven't heard from any of our companies that somebody has problems adopting patent standards. However, it's a hot topic abroad, so probably we have our own terrain, so to say, and based on that terrain, we have to strike a balance. We won't be able to just copy-paste it from abroad. I cannot keep silent.
You mentioned the privatization that we have 20 years ago, and I would like to remind you that the market was created only after the privatization, and this market accommodated hundreds and thousands intellectual property objects, and we're not speaking about just candies or any other petty things, but we speak about the important things. You also mentioned the methods used by FAS, and I want to reassure you that the mechanism of costs is not the only one which is used. Unfortunately, we are forced to consider all issues because our Ministry of Trade or Ministry of Economy doesn't have the qualified experts. And being a representative of the dominating company, I can say that it's not a state regulation, it's a self-regulation. Well, I cannot miss these comments because they have the principal importance for our discussion. Well, privatization has a long-standing history of discussion because we speak about pledge auctions, and we can say that we created a market, but at the same time we created an ongoing problems of property reshuffling and redistribution. More than 90% of respondents believe that this privatization was wrong, that it was not fair. Well, luckily, we are not discussing the legality of this privatization. So we cannot just close our eyes and say that, okay, it was 20 years ago and finally it's over. It might have been better. Article 6 does have two methods for the evaluation of monopolistically high price. But if we look on the second criteria, we can say that it's rather rigid. So as the answer we get either yes or no. But in 90% of cases, these are great areas, and we can only speak about higher or lower comparability. So I read now and then that there is no comparable markets. And we speak about the cost estimate method. Or there are trickier approaches. The notion comparable market is not used, but de facto information from other countries are used in the estimate. So it can be interpreted as a comparison to the comparable markets. I never mentioned that it's not used, but due to the fact that this is really unflexible, very rigid instrument, we are forced to use regulation tools. Regulation, self-regulation, that was the third issue. This case can be interpreted the way you like it, because it's your personal statement and your personal view. I doubt very much that this is a self-regulation by oil companies, because after the first attack and the second attack, they will be the first to shout that it was done by themselves. Business is a routine activities. Of course, there are some practices, but the question is whether this trade practice is regulated or not, whether it suits it doesn't suit to business. Maybe this business practice is just a pretext to get rid of the antitrust authority. But if this business practice is damaging the processes, it impacts costs and revenues. It's the pockets of the consumer that will be the help of last resort. If trade practices are developed by
and we will obviously, it's a quite a hot issue in Europe as well. Excessive pricing has always been. President Artemyev?
Да, но я просто, чтобы чисто российскую тему не развивать.
Well, I would like to come back to the main issue. I want to make a comparison with the code of arbitration. So if the argument is not contested by the other party, the judge will have to accept it. Andrei Evgenich has just criticized everything we heard. So he wants to kill all innovations. All novels that we believe to be crucial for the progressive development. I do admire your position, but I don't like your arguments. It's not the right place to go into details, but I just want to note that we nearly abandoned the cost evaluation method. We usually use the comparative markets method. So you, as being our main respondent and a well-known scientist, are perfectly able to calculate figures. Why I don't like economy? It's a word against word. In my beloved physics or in my beloved chemistry, it's formula against formula. So I just want to use the language of formulas with you. Well, and I still believe that antitrust intellectual property is much more important than these minor discussions.
Вознесенский Николай, практикующий юрист.
Nikolai Voznесensky, practicing lawyer. Nikolai, I want to ask you several questions. So you said that antitrust service can begin to act without waiting for any legal initiatives, and it can interfere when the prices are excessive. So the question is, do you really want to spread the intellectual property rights on the competition if you have all the relevant tools? Well, the answer is very simple. We can punish, but this right holder may leave the country once and forever, and we shall not be able to bring him back. Of course, we can use sanctions against this company, but the company will leave this market. We shall worsen the situation for the social benefit and for the social wealth. So if we force this company to grant a license, wow, these forced licenses are extreme cases. We would prefer to use mild approaches. For example, we discussed the intra-brand competition. When we say that exclusive dealership is prohibited, there must be at least 3 dealers not related with each other. Next is, let's say, transparency, and if you provide same discounts for the whole sellers, and everybody can see that there is no discrimination, it's a good, positive example for the rest of the market. Trade practices, however strange it might be, open good perspectives for competition, and there is no need to use hammer and sickle to fix the situation. We suggest discussion, soft regulation, a kind of transition period with compromise decisions. Because we also faced the worsening of the investment climate. We cannot make it still worse. So all that together is called an antitrust policy or the economic policy, and that shows to us that we don't need to use the haircut lines and use severe sanctions for each and everybody. We just need some showcases, some really very targeted actions. I don't want this situation to last forever. I just really to use some examples, delivering our cases to litigation, to courts, to demonstrate to general public what we are able to do. But on the other hand, we don't want to be too tough, because being tough is being unpopular.
I would like actually to ask Judge Marcelo to comment on this, but also for 5 minutes, if you can know more on the issue of sector-specific intellectual property, please.
Я хотела бы очень коротко остановиться на...
Yeah, briefly about the issues that we have been discussing. Well, 2 main aspects to highlight. But that's my personal legal judgment. If we want to make alterations into the antitrust law to let's say, fix the cases when right holders abuse their powers. Just some corrections to the definitions. Of course, the intellectual property, I don't like the notion. I don't like the word property. Well, the only feature of property is the fact that we have to defend it. But let's say the right holder may be granted the rights only by this short period of their monopolistic application. I will not go back to the issue that was discussed 200 years ago. I would rather want to speak about the alteration of the antitrust law. I don't believe it's necessary, and it stems directly from your question. I believe that the current legislation already allows to counteract the abuse on this market. We have Article 10 in our civil code, who allows to trace this misconduct. Plus, I'm speaking about new version of this article that gives a broader definition of misuse and abuse of rights. And I believe that the majority of cases that were defined here are fully covered by Article 10 of the Civil Code. I would like to remind you that the High Court of Arbitration used to work with Article 10b of the Paris Convention that allows direct estimation of the intellectual property's right violations. So I don't think that we should be in a hurry and start modeling, shuffling, and changing of our antitrust legislation, because it might be frightening to any right holder. So we shall just create a bad image that would be very difficult to change later on. I believe that the wording of our current legislation is good enough and gives all rights and remedies for right holders or violators. Plus another topic, whether it's needed to maintain the patent system. Well, of course, it's not the question for today. It's a topic to be discussed on the international level. Can you imagine what will happen that if we say Russia Federation refuses to grant patents and we shall invent some new way to protect the rights? I don't think it would be very positive and wise on our side. But I think that this topic should be tackled. The patent system appeared by incident. So let's say there were times then inventors were just granted these privileges. Later on, this granting changed into registration and selling of rights. Well, what was the essence of the patent? First is to disclose the information about the invention. Many other possibilities which we use today do not resolve this issue. For example, let's say know-how, it's just a process. We don't know how this process came to existence. So when we see a patent, we know what's behind, even if we don't understand, but we know that there is something behind this invention. So we need protection for inventions. We need protection of the rights, scope of coverage, time of application. So I believe it's a tremendous task for the future. But today, coming back to the topic of our discussion about this interface between intellectual property and competition, we can say that the current trend in legislation and in litigation is not to harm. We always protect. We protect competition. We protect right holders, and it's usually very clear statement with excuses and apologies that we do respect the rights of the holders, but there is a violation of human rights, violation of competition, and so on and so on. In our magazine, Patents and Licenses, there was an article that ended up with the following phrase: let the courts accumulate the practice, and we shall see where are gaps and deficiencies, and we shall know for sure what must be subject to regulation and what should be left intact.
Which discusses actually the third and last question of this forum, the interaction between institutions, between institutions of intellectual property, law judges and intellectual property offices, but also competition authorities, as well as his thoughts on the interaction between competition law and intellectual property. If we can show the video, please.
Chairman of the U.S. Federal Trade Commission, to talk about how U.S. antitrust agencies and the Antitrust in particular have changed in their approach over time to dealing with intellectual property. The main message in my presentation is that incorporating competition policy into the treatment of intellectual property is emerging better, and that the current effort to rethink the exclusion that takes place now about this law, I think, is entirely appropriate. What has happened in the U.S. has been a dramatic adjustment in the emphasis of competition law over the past 30 years. From an approach that regarded intellectual property with great hostility and suspicion, to one that now seeks to incorporate considerations of intellectual property and innovation more directly into the formulation of competition policy and the application of antitrust law. Let me mention two important adjustments that led to this rethink. One was a set of hearings that took place in the mid-1990s that focused on high technology and innovation. Those hearings underscored that to a large extent, competition law and intellectual property law serve complementary purposes. That is, both ultimately are keenly interested in promoting technological progress, innovation, dynamic adjustment in the economy, and that each, through a different path, seeks to improve economic performance by elevating the significance of innovation and new product and process development as key ingredients A second important milestone was a set of hearings that took place in 2002, in which the Federal Trade Commission, the Department of Justice, that is the other U.S. antitrust enforcement agency, and the U.S. Patent and Trademark Office collaborated in 25 days of hearings that focused on competition policy and the U.S. patent system. And a key item in those hearings was the extent to which improvements in the intellectual property rights granting process could improve economic performance to take account of competition policy concerns in a much more conscious way, and while still maintaining important incentives for innovation to improve economic performance by reducing competitive barriers to growth and development over time. Several important lessons emerged from this set of hearings that resulted in the publication of a report by the FTC in 2003 called To Promote Innovation. The first lesson was that indeed competition law and innovation-related protections in the intellectual property sphere are complements, and they're not substitutes. They do largely seek to achieve the same ends. But a related finding was that competition is a crucial force for promoting innovation, that it is not simply the protection of property rights through the granting of patent, copyright, and trademark that promotes innovation, but the competition itself is a vital spur to innovation and growth. So that to ignore the contributions of competition is to see only one part of the innovation question and to understand it fully. A further lesson is that the operation of the rights granting process itself can, unless it is properly conceived, can diminish competition and can diminish rivalry. That it is possible through the granting of weak patents, weak in the sense that they do not fulfill the standards of patentability, the failure to have an appropriately rigorous mechanism for examining patent applications, and to challenge improvidently granted patents, or to promote the contesting of claims that in some sense are excessively broad or ill-founded, that without having robust opportunities to test patent rights and to ensure that standards of patentability are satisfied in applications, one would see the granting of too many patents which would impede the functioning of the competition that drives innovation in many sectors. A second key lesson from these hearings was the importance of taking into account in the formulation of competition policy and IP policy the perspectives of these two disciplines. Unmistakably, it emerged that there were great gains to be had from deeper cooperation between antitrust authorities and rights-granting authorities. And over the past decade or so, we've seen in slow steps a progressively greater amount of cooperation between, for example, the FTC, the Department of Justice, and the Patent and Trademark Office. I wouldn't say that there was a deep integration of activity, but there is a much fuller discussion, conversation that took place in the past. And in a number of instances, we see these agencies working together to come up with common approaches. Recently, the Department of Justice and the Patent and Trademark Office, for example, issued a joint statement with respect to the enforcement and application of remedies in certain types of IP-related disputes. A final and important lesson from this process is that competition law does have an important supplementary role to play. That is, by analogy to the Russian approach at the moment, to exclude IP rights completely from examination, to exclude the consideration of how IP rights are applied from the competition policy system, is to create a blind spot. An appropriate time, I think, for Russia to rethink the exclusion that exists now. So that when we look at the U.S. experience, we see a significant evolution over time in policy. We see the recognition for a much deeper engagement by competition policy people and intellectual property people, not simply at the level of government policy making, but at the level of practitioners and academics, that this is a very fruitful area for cooperation and additional common work in the future, that the IP rights granting process is a worthy subject of consideration, that if it's not functioning well, it can create significant competitive distortions that diminish innovation and growth throughout the economy,
And last, that competition law has an important role to play, properly conceived in different areas, in addressing the misuse of intellectual property rights, exclusion, improper exclusion by firms that have intellectual property rights, that the types of reforms that are now being considered in Russia have real merit, and that this is an appropriate time to reconsider the relationship between competition law and intellectual property in Russia, part of a larger trend that we see taking place around the world today. Thank you very much for the opportunity to speak to the group.
So I would like to ask if there are any thoughts from the different members of the panel on this. We're already 6 o'clock, and I guess everyone is a little bit tired. So we might probably end up with this optimistic message of cooperation and complementarity between intellectual property law and competition law. I would like actually to just give the floor to President Artemyev for a moment. I would like to give the floor to you because you have something to say. Yeah.
Нет, я не...
No, I don't want to draw any summaries because the audience is so representative. We had a really interesting conversation, and it serves as a food of thought. I'd like to do one pleasant thing. The thing is that the Federal Anti-Monopoly Service, represented by its management, decided to present a diploma to the Baltic Brewing Company for developing fair competition. This diploma, the decision to present it was made long ago, but only here in St. Petersburg we have the physical ability to present it to the representatives of the Baltic Brewing Company.
Much, President Artemyev. Thank you all for this excellent panel with a lot of fruitful ideas, and thank you to the audience that has been very passionate and hasn't complained from the fact that we did not have a break. But as you saw, it was very difficult to have everyone talk and discuss and at the same time have a break. Thank you very much for your attendance.